Welcome to the Clerk podcast. This podcast is separate from my role as an attorney. However, it is my job to educate, entertain, and teach. And to put it in context for you, take a look at this.
Counsel, I have to report this to you, and I am very, very unhappy about it, but there's nothing to do but put it on the record, and then I will proceed with questioning the rest of the jurors.
I know you're probably busy, but if you have a minute, we'd love if you could like the video, and that helps us get more viewers just like you.
The jurors' cell phones were not confiscated or taken from them, and they tune this thing in on court TV and listen to all of what just went on. You may make whatever statement you like to make, and then I'm going to go on and question the jurors. I will tell you in advance, I am not going to stop the proceedings or do anything to interrupt them. I'm going to get the rest of this on the record. You might imagine that they no longer have their cell phones with them.
I had a professor in law school. This professor was from the South. He's from Texas. And he said, some people call it voir dire. Some people call it voir dire. But where I'm from, we call it picking a jury. And that's really what they're doing. They're picking a jury.
The judge brought up another thing right after sentencing that I want to explore with you briefly. One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits presented in this case that were photographs of the two decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge. They were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the...
I'm talking about the fact he alluded to it on sentencing.
So did she see some documents that she was not supposed to because they should have been sealed?
And said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
It wasn't me. It wasn't me. It wasn't me. It was the member in the gallery who had taken a photo of the exhibits, which is possible.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits, and you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. J. Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Posting Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
So to prevent people from getting access to them, they were being extra careful is what she's trying to say.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
What was the methodology for allowing them to examine the exhibits? How did you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures. And everything was, all of the pictures were looked at by the court reporters that were there and the lady from court administration, along with someone from my office and Mr. J. Bender, to make sure that everything was done correctly.
So this is the clerk of the court who has gotten in a bunch of, bunch of investigations have taken place because of some of the allegations that have come up since the trial.
What I'm asking is how you handled having them, the press, view these exhibits.
If I remember correctly, the press, we had certain designated photographers and then someone, I think, from the state of or the Post and Courier, and they were responsible for putting it out on a stream for the rest of the media to
And
access.
would they do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
I don't think that the judge sounds like he's buying it. I think he believes that some kind of a leak happened with these sealed exhibits.
And so you think that you're aware of the fact that some of these on-the-scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am. Yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
From who?
Of it. The conversations that go on among a trial team when we're not in open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors, those types of conversations go on, but that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear. And I
Miss Becky is the clerk. Who's Miss Rhonda? Let's see if we find out.
probably was as repetitive as anyone here today and asking that question over and over again because I didn't want that point to be lost. That Miss Rhonda said, I was there more than anyone else and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, this needs to be fixed, something's going on.
Miss Rhonda's probably works at the clerk's office. That's my guess.
Improper. And I think that that is an extremely crucial fact because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened.
Well, Miss Becky just said she wasn't there very much.
We have the clerk of court come in and testify. Maybe I did this or maybe I did that. Maybe I plagiarized the book, a portion of it. Maybe I
How did she plagiarize the book?
did this. Maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry.
She wrote the book. The book is going to be very relevant because she wrote the book. And so those are going to be statements directly from her or the ghostwriter. That's interesting that he would say the book's not relevant at all.
But she was clear that she did not have any attempt to influence that jury.
So what is the book? The book was her take of what happened on the trial, what took place in her point of view of the trial, as in a lot of statements about her perception and what she took from the trial and what happened during the trial.
She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? Defense, I think in one of their letters, tried to say that Miss Becky was the state's star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict deliberation, we would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Ms. Becky said and ultimately what Ms. Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Ms. Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Ms. Becky and Ms. Rhonda do is corroborate who are the most important witnesses, and that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced, nobody tried to influence, and regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair.
So the first video that we watched at the very beginning was about a juror watching the court, as in probably right here, something along these, open court, the attorney talking to the judge, without the jury being in the courtroom, watching court TV on her phone. I say her, I don't know if it's a man or woman. I'm guessing that maybe multiple jurors were looking at a phone, maybe watching what's going on in this. Or maybe one person was just sitting there looking at it. Not sure. But we do know somebody was doing it on the jury. Each attorney essentially has bullets. A little bit graphic, but that's the explanation that he gave. So you're essentially deciding who to use the bullets on in the jury. And you only have, let's say, 5 or 6 bullets in yours that you can use for no reason. Maybe they have a bias, and the judge will remove them for no reason. And then once you use all of your bullets, and then the other side uses all their bullets, then you've got your jury. Or you just have to figure out who's on the jury based on the number of the jurors. So let's say you start with 40 jurors, and 10 of them are going to be on the jury. Well, you're going to have those jurors listed 1, 2, 3, 4, 5, 6. And if you don't use all of your bullets, or you use them all, it's either way, whoever is left in those jury box seats stays on the jury. And then the rest go home. And you might have an alternate who's not even on the jury, who's just sitting there, just in case one of the jurors doesn't make it through the trial for whatever reason, whatever obligation that they have.
Your Honor, we would submit that the motion for new trial be denied.
Mr. Harpootlian.
Mr. Griffin will be arguing.
All right.
I want to first start with State v. Green, because I understand that that's the guidance, that's what we're following here, and reading, excerpts from State v. Green. First, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Whether the verdict would have been different, is it prejudicial? And I'll keep reading The court says we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different, it was their prejudice, was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial. The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by bailiff to a juror rises to the level of constitutional error.
And I think that's a good point. Would the verdict be different is not what they are looking at, because it's hard to know and if the verdict would be different. I mean, the true piece of this, that might be dead flat out, this person is guilty, that you have all the evidence and it is super clear. But that's not the standard. The standard is, would it be prejudicial? Prejudicial could be slightly prejudicial. It doesn't have to be substantially prejudicial. It just means prejudicial, that the process was done so in a tainted way. And that is outside the scope of the evidence. That doesn't mean that this person is guilty or innocent. It just means, was the process procedurally done fairly, or was it done prejudicially?
Goes on to say the attempted bribery of the jury in Rimmer conduct, which goes to the heart of the merits of the case, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice. I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption. That we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we prove prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember. And then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this, quote, this shouldn't take us long, close quote, and that if we deliberated past 11 p.m., that we'd be taken to a hotel.
Okay. I hope you all I don't want to repeat everything that was just said, but those are the statements that the jurors supposedly heard Miss Becky make. So what is your question? So how could Miss Becky make all these statements to the jurors? Well, it's pretty unusual because usually we don't have the head clerk so involved in the everyday, day-to-day situations of the jury. That's usually left to judicial assistants, law clerks that are in the courtroom. But this is the head clerk in the courtroom having what seems to be conversations with the jury. And you can make your own decision for yourself if those conversations were gossip, if those conversations were inappropriate. But what the defense is saying is that Miss Becky is having conversations, gossiping about the defendant, and that tainted the jury pool. That's exactly correct. And that was the clerk who was on the stand that we were watching just a few minutes ago, which is interesting because if you remember from a minute ago, she was just on the stand saying that she wasn't that involved, that she wasn't the person who was intimately working on these exhibits, and that she wasn't really there. But when you have the jurors talk about these conversations, it seems like it's at odds with her statements from only a few minutes ago. Well, it's not too much about involvement. She could have had said one of these statements, one of these things, and that could be it. It sounds like there's a few statements that they're relying on, maybe to multiple jurors, or that multiple jurors said that she made. And that's really just kind of accumulative. If she made any of these statements, then the question is, well, what is going on? Is there, as they were saying, is that tampering? Right? Was there contact that was sufficient to be considered tampering with the jury? And, tampering could just be a seed being planted in the jury's mind that this shouldn't take long, that you're going to see through the defendant's statements, that you're going to see the kind of person that he is. Those would all be highly, highly inappropriate statements if those were the statements that were made, because it's going to take the whole judicial process. It sounds like there's two pieces to this. Maybe you can find either way that there should be a retrial. One, if her statements attack the merits of the case, of their case. Right? If it is specific that they were saying this is true, and she's saying, no, you can't because he's going to be malingering on the stand or something like that. That's number one. Was it prejudicial? Was her statements prejudicial in so much as we can't have a fair trial? We couldn't have a fair trial because we don't want to have trials like this. We don't want to have trials that are influenced by anyone. The only people that can influence the trial are the people involved in the trial, not from government employees.
Those statements go to the merits. Those statements will go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's two deliberating jurors down. The third deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. She crossed herself up. As Your Honor is questioning her, about the transcript involving the egg lady and how the egg lady learned that that there was some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Miss Hill told her, and that pretty much came out there. I mean, so, you know, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I mean, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard, and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight.
Who's Miss McElveen? I don't know. The jurors are jurors X, Y, P. Alternate for Miss McElveen 5, but I never heard of Miss McElveen. So I'm guessing that's somebody working at the courthouse.
And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill said, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, you know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask, how? And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes.
So were the jurors influenced? According to one of the jurors, at least, the answer is yes. They're saying that she made them feel as if the defendant was already guilty of the crime before they even made their deliberation, according to this defense attorney. And so once that comes into play, now, according to the defense, there's a presumption. Once there's a presumption of prejudice, now it's up to the state to then go and overcome the presumption. And so you can decide for yourself, based on that, was the defense's argument that they weren't influenced. There's 12 jurors altogether, and it sounds like the defense is saying, well, they made those statements that they weren't influenced, but they also made these statements, as we've talked about. How did this all come about? The defense reached out to the jurors. That's my understanding. And what I've heard that's publicly out there is that the defense reached out to the jurors. They might have heard from a tweet of a bird somewhere, just some kind of maybe it was gossip around the town that the jurors had been making these statements, or I don't know. But what I do know is that the defense contacted the jurors, and the jurors made these statements to the defense. What are those statements? Well, Miss Becky had told us such and such during the trial. And they're like, then the defense is like, well, that's a problem. That's going to potentially have poison the jury. And that's frustrating. I'm sure it's very frustrating for the state, very frustrating for the defense. Statements from the clerk is really not a common scenario, and not a scenario that I'm sure isn't very problematic for the whole system, everybody involved. So, are they going to have to do a retrial for this Alex Murdaugh? We have yet to find that out. The judge is going to make a determination based on everything that you've heard here and based on what you've seen, you could be leaning one way or the other. We won't know until the judge decides. As you know, you heard earlier that the judge was questioning Miss Becky, and that could seem like the judge is against her. But that's not how it works. The judge is just making witness statements and trying to get evidence because of what's going on here. And that's what the judge is supposed to do, because the judge is going to then decide if there's going to be a retrial or not. So based on that, we won't know, but we will know when the judge makes their ruling. Make sure you subscribe to the channel. If we hear any from the judge on their decision, we'll be the first to update you when we find out whether Alex Murdaugh will have a retrial or not. If you'd like to see more true crime with Laura Cliff, click the video right here.